Hi, this is Brett Cenkus. I'm a business lawyer specializing in mergers and acquisitions and an M&A advisor. And today we're talking about the life of an M&A lawyer, or the job of an M&A lawyer. So perhaps you're a student and a lawyer looking to change fields. Today we're going to talk about what an M&A lawyer does and the good and the bad, the pros and the cons of it. Before we get into this, if you want to book a paid call with me about this topic or any other, you can go to clarity.fm/Brett Cenkus, and I can almost always accept a call for the same day. So check that out. Now let's get into it. Before we do, let's just keep in mind that the job of any M&A lawyer, or probably just about any profession, is going to vary significantly by the company in which they work, or in this case, the firm in which they work, the other lawyers with whom they work, the clients they're able to bring in and work with. If they specialize in certain industries, which a lot of M&A lawyers do not, but some do, that's going to influence things. The size of the firm certainly is going to be a big driver, and geographic regions can drive sort of all of those things I just mentioned. So there's a lot of factors that are going to influence the specifics of what it's like to practice as an M&A lawyer. However, there are a lot of commonalities, and so let's get into them. I would group the work of an M&A lawyer. Well, first off, most M&A lawyers also do other law, and M&A is a subset of just corporate or transactional law. And I have a couple of videos out about corporate and transactional law generally, but it's business law. It involves almost always a business and a contract, and it's distinct from litigation. So most corporate lawyers will spend their whole career never going to court. Never. Now, I do sometimes, just because I'm just curious and like to put my hands on other things, but it's a very, very small part of what I have done over the years. But most transactional lawyers never see a courtroom. It's not what they're doing. Their negotiations are, they're not making arguments to judges. They're negotiating with clients and drafting contracts. Okay, so M&A is a subset of that. Most M&A lawyers outside of big law do other things. We do other things, although we specialize heavily in M&A. We pick up other work for, and that's why I have other videos out in the world and clients who ask us to do a lot of other things. Working on mergers and acquisitions as a lawyer, there's 5 major categories, or I'd say there are 5 distinct categories of tasks. The first is going to be documents, and that's preparing agreements. A purchase agreement is the main one. An asset purchase agreement or stock purchase agreement or a merger agreement, just depends on the structure of the deal. Those are all different ways to buy a company, 3 different ways to buy a company. And so 3 different titles of a document that fundamentally accomplish the same thing, where buyer is acquiring in some manner the business of seller. And then there's ancillary documents that go along with that. That could be non-competes and stockholder agreements and escrow agreements and consulting agreements and loan agreements. If there's seller financing, there's all sorts of stuff that goes along with it. We call ancillary documents, but the main document in every deal, if it's a $1 billion deal or a $1 million deal, is going to be some sort of purchase agreement. And the M&A lawyers are responsible for delivering that. Now, the buyer's counsel usually does that unless it's an auction or sort of a unique type of sale structure. But typically the buyer's lawyer is going to do that. And then the seller's lawyers are going to respond to it. So they're going to read it, make comments, say you forgot to put this in there, and add it and work on that document. And they're going to go back and forth with, if there's investment bankers and clients, other people will have comments, but fundamentally that process is led by the lawyers, and also all the ancillary documents as well. And disclosure schedules, which that leads us into disclosure schedules, are a certain type of, it's an exhibit essentially, an attachment to a purchase agreement that just sort of fleshes out the purchase agreement. So there could be sections of the purchase agreement that say, all the employees of the company are listed in Schedule 1.8 or whatever it is. It's so these disclosure schedules kind of go along with it, and the lawyers are usually leading that process. And that brings us into the category number 2, because it's part of the disclosure schedule process, is due diligence. So due diligence is the process of kicking the tires, making sure the company you think you're buying is the company you are buying. It also is a term that comes up in other contexts like financing and so forth. But in M&A, it's the process of the buyer getting in there and looking at all the seller's contracts and leases and employees and arrangements and debts and figuring out, is this everything I think it is? Trying to really understand the business and decide for sure if they want to buy the business. Lawyers are often heavily involved in that process. Now, that we are less involved in that process in the lower middle market. I mean, when I worked at a big law firm and we worked on billion-dollar deals, they were heavily staffed, and junior associates were looking over documents. I can recall flying to Washington, D.C. one time, and there was 24 of us from around the country. It was a big law firm who would come in just to review contracts all day, essentially for change of control provisions. In other words, like what happens when we do this deal? Do we have to get the counterparty's permission? But other things too, just things out of the norm. If we're stuck in a contract for a long time, there's a huge penalty to cancel it. So that work is going more and more to automation, and it's going to go to AI soon enough. But diligence is still an important part of what we do. And even if clients on $5 million deals don't have the budget to pay us to do all that contract review, they still need our help figuring out how to do it, what they're looking for, and when they find something, whether or not it's relevant. So diligence is a big part of it. Okay, third major category is structure and deal logistics and management. And so really what this is understanding how the deal needs to flow, the steps, counseling the client, informing them about what's going on. If things are stuck or not moving forward, helping the client understand how to do that, helping the client understand what's normal, taking some of the emotion out of the process or helping them contextualize what's going on in negotiations. So overall, you can help move this deal to a closing. A good M&A lawyer is going to help get deals closed. Lawyers have a reputation for killing deals. That is, some do kill deals. But in my book, this is more about some things come up and maybe I spotted it, but I'm going to do the best job I can of helping my client decide, do they care about this? Is this important? I'm not going to tell them, you can't do this deal. That's crazy. It's all business risk. So when things come up, it's helping them understand so that they can kill the deal if they want to kill the deal. Again, fundamentally, it's killed by the thing that came up. But a good lawyer is going to help a client understand those things and what's normal, what's likely to come up, when to go back and revisit what you agreed to under the non-binding letter of intent, how all this process works and what's normal, what's not normal. And that also falls in the range of like structure of the deal. How should we do this? What are the implications of it? There are specifics about structure that are there's tax consequences of various structures of deals. So if you're buying assets or buying equity or merging, and a good M&A lawyer is going to understand a lot about that, at least enough to spot issues, enough to not worry about bringing non-issues to the specialists. At some point in time, we're going to say, look, this, you ought to engage someone who just does this, right? Just does tax. But understanding finance and tax, we'll get into the skill set of an M&A lawyer in a minute, but that all falls to me under this idea of structure, process, management. It's a big part of what we do, and that turns into really advice and counsel to the client. Okay, fourth category is going to be regulatory and compliance. And so that is... and this isn't a huge part of my practice because of just the nature of it. And remember, I said earlier on that who your clients are and who you work with, the size of your firm and the size of your deals, and those things will influence a lot about the details of what you do day to day. But this category still shows up. It shows up at bigger levels. You've got antitrust compliance. So you've got filings you've got to do for antitrust purposes. There's certain regulatory deals where there's filings and approvals that you need. In foreign countries, that's often the case. Or special technologies and things like that. If you got certain permits or FCC licenses, things like that, there's approvals that you need. I put that all in the regulatory and compliance bucket. There's the permits and licenses and so forth that the target company owns that sometimes need to be moved over to the buyer's name, or they're invalidated, I guess is the best term for it, upon doing a deal, depending also on the structure of a deal. So helping a client understand those things and when they need to go get new approvals. There's often securities law issues that are raised if we are paying for the business. If I'm representing a buyer and we're paying for the business with stock, that's an issuance of a security. It's regulated. And then it's as the seller, if you're selling your stock, it's also securities law issues on that. It's easier to navigate. But the point is there's that also I put on the bucket of regulatory, so in compliance and things like that. So you might also talk about things like employees and 401k plans, and are they triggered on change of control? I mean, that's more contractual and really in the fifth category I'll get to in a minute. But there's a lot of stuff around the nuts and the bolts. So we're not talking about deal structure or drafting an agreement. We're talking about spotting approvals that you need and things that are different. So the fifth category is just a big bucket of just other stuff, ancillary things. And a lot of this is operational. So I started saying under the regulatory category that 401ks and employee sort of issues and those are kind of in that bucket. Well, they may and they may not be. If you're laying off a lot of employees as a seller in connection with the transaction, there's the WARN Act and there's requirements, things you've got to do, notices you've got to give. So that would all be sort of employee and regulatory related in my book. But then there's things that just come up like how to talk to the employees, when to talk to the employees. What should I do with my best employees if the buyer doesn't want them? Or how do I kind of help them get a soft landing or, a new how do I transition over to the buyer? There's things like that. And they'll want our advice because we've seen it a lot. And I've also been out of law for a long time during my career. And I've been in the shoes of a business. I've sold my own business and I represented a public company in buying businesses. So I've got other looks at it and that's not just unique to me. A great M&A attorney picks up a lot along the way and often has a background in finance and things. So they've got something to offer, the experience that falls into this category. Our clients we're sort of the first one they come to ask, like, what should I do about this? Or this issue just came up. Or even if they've got employment counsel, it's off. If there's some sort of major issue, let's say there's a sexual harassment claim during the signing of the letter of intent in closing, they're going to come talk to us about it. They're going to talk to us about it to want to know, what do I do with this? But fundamentally, they're going to need to know, how do I disclose this to the buyer? I mean, because they almost certainly need to do that. So those are the categories of kind of tasks, work, what's going on. The skill set that a good M&A lawyer is going to have is going to be, like most lawyers, analytical and detail-oriented, very important. It's a big part of this job. I mean, some of it's very strategic. That bucket number 3, deal process and logistics and management, that's all high level. But documents, preparing them, negotiating, reviewing them, negotiating them, that is analytical and detail-oriented. You need to spot issues and you need to look at that paper carefully. So that's important stuff. Negotiations and interpersonal relationships, very important. So everyone's got different negotiating styles, but you've got to have a style that works for you. You got to be comfortable with it. You've got to not be afraid to go in and make the client's argument. You got to be not afraid to make it on big conference calls and to present it cogently, quickly, and in the best light. So that's an important piece of it. Interpersonal skills isn't just negotiation. That's going to come up in how you manage the clients when things get very emotional, how you're able, it's very important to be able to convey to them objective information, but have them not feel like you're on against them, right? So it's very often that I'm talking to clients and say, look, I got your back. We'll do what you want to do. I just want you to understand that this is not an unreasonable ask. And it's likely that you would have this same ask from any other buyer. We'll fight it if you want to fight it, but I want you to have the right information to contextualize and understand it and decide what you want to do. And that takes a certain nuance sometimes, especially if you're doing it a lot. Clients can easily start to feel like, whose side are you on? So there's a lot of things in sensing that, right? And how to handle that. And, and then there's finger pointing. If things aren't moving fast, how to navigate all that without throwing people under the bus. There's a lot of just management of people and processes that require a certain degree of sort of tact and self and social awareness. Very important. Problem-solving skills are important. To be a creative, not an artist, but creative, able to look for unique angles and be able to solve problems and understand, and this kind of goes back to maybe interpersonal skills and self-awareness, what the side's different motivations are, and then be able to suggest solutions to get over hurdles and impasses in deals, different ways to do things. And so some amount of creativity, some of this comes with experience and having seen a lot of things, but also fundamentally being driven to solve problems. And how do we keep this deal moving towards a closing? A financial background is very important. Accounting would be great. I don't have I understand a lot about accounting. I'm not formally trained in it, but I've got a lot of finance background. And so those things are really helpful, not critical, and things you can also pick up if you're a bright person. It's so easy to pick up anything these days, online. And so you can self-teach. But if numbers are very difficult for you, if you weren't good at math, if that was sort of scary stuff, you're going to struggle in certain aspects of M&A. It doesn't mean you can't be an M&A lawyer. It's a small part of what we do, but we are often putting together not financial models, but Excel spreadsheets to model out the flow of money or figure out the impact of like where the purchase price flows to the different sellers, the owners, the shareholders. There can be, they call them waterfalls or different preferences, like figuring out how to do these sort of things. We spend a decent amount of time modeling things out in M&A, not 20% of the business, our work or anything like that, and then being conversant in those things because the deal gets put to paper. And I said earlier, a big part of this is documents, preparing and negotiating the what we call the definitive agreements and the purchase agreement. First and foremost. So a lot of the concepts in there are financial. They involve working capital. They involve accounts receivable and debts and things. So understanding what's going on so you can translate what the client wants into contract-specific wording is really important and would be challenging to do if you just weren't conversant and comfortable with numbers and finance. Again, I don't think you need formal training. And even if you are just terrified of numbers, you could still be an M&A lawyer. But it's something to think about for sure. Okay, and maybe the last skill I'd say is the ability to stay calm under pressure and be level-headed. Deals all have their sort of pressure and emotion, and that really doesn't change from billion-dollar deals to million-dollar deals. Now, million-dollar deals, you don't have the pressure of public markets and timing and things like that comes with, billion-dollar deals aren't always public companies, but they usually are. And so that involves other levels of time and pressure so things can get done before leaks are given to the market, before leaks go to the market. So I'll talk about that in a minute when I talk about pros and cons of the job. But it's still... it is still pressure on every deal, and there's emotion, and being able to stay calm and make sure your client feels like you have their back, but be okay and just a calming presence when things start to get a bit crazy, and not being too. Again, you want to make sure your client thinks you've got their back, and you're not happy either when you get a curveball from the other party, but it's like, okay, let's figure out what to do and stay solution oriented. It's very important to get deals across the line. Okay, so the good and the bad, pros and the cons. Okay, number one, the trajectory of deals or the pace of deals is a good thing in my book. So in other words, deals move along a little slowly, and then they heat up, and then at the end they're really busy getting something to the closing table, and then it's done. And now most lawyers have other work they're working on, they have other deals they're working on. However, there's a certain ebb and flow that has go, and then a pullback and a little bit of, good time to take some time off or just settle back down. And so I like that. I like not always being in a fire drill, but not always just coasting along. I mean, I think it's really exciting at the end when you've got to put in a few late nights. I don't mind that just to get a deal closed. It's a great feeling when you get it closed. So that's exciting. You get M&A is also a diverse practice. Generally, again, this is one thing I said it early on, will vary from M&A lawyer to M&A lawyer, but we don't niche down in particular industries. And most M&A lawyers, certainly at lower middle market kind of levels, do not. And so we see a lot of different businesses. We see what made them successful. Someone's buying them. We have to get in and understand a lot about what they are in the process of doing due diligence and disclosure schedules and making the contract terms fit. So you get to see a lot of things and pretty sort of quickly. And in a given year, I work on 30, 40 deals, something like that, I guess. And so you're seeing a lot of different businesses and industries. And I love that. That's very exciting. It was one of the reasons I wanted to be in private practice after being in-house for years. It's because it scratches that curiosity itch. And I had a friend who worked on a case. She was a litigator for a big law firm and worked on one case about a very niche. I mean, it was a multi-billion-dollar case, but a very niche technical patent law related issue. And it was just like, look, you spend 3 years of your life and that's all you do. That's just, I would not like that at all. So you see a lot of different things. It's very interesting. And you work with a lot of different people. So deals get staff. There's teams on deals. You got investment bankers or brokers. You got CPAs coming into getting involved. Bigger deals, you're dealing with the CEO and the teams, different people on the teams. Meaning at the company level. So you're meeting a lot of people, dealing with a lot of people, building your network, and kind of then moving on again. So I think that's unique to M&A because versus our other corporate practice where we are working with different people inside the company, right? I mean, it's the CEO, the COO, the CFO, whatever. But you're just dealing with the same company day in and day out, which is great. It's regular business. They come back to you with questions and work and contracts and things like that. But M&A spins up for a moment. You meet a whole new team. You work with a whole new group of professionals, and then you kind of move on. So that's not just the trajectory, but you're expanding your network and reach and collaboration in many ways. Okay, fourth pro, I would say, is clients are generally happy at the end of the day, and we're all rowing together towards the same goal. So you're negotiating, there's no question, and there's emotion, and sometimes parties are upset. Right, and sometimes they're very worked up. But fundamentally, compared to litigation, for example, or bankruptcy, which we sort of think of both as lose-lose. Well, maybe not bankruptcy as much, but the point being, like, there's a lot of unhappy groups in those processes. If we get a deal closed, both sides are happy. They might feel like they were, at the last minute, had to give too much and be a little bit salty, but fundamentally they wanted to do that deal. They wouldn't have closed it, and they're happy. And usually they're quite happy. I mean, both sides are very happy, and that's nice. I mean, fighting all day, I don't mind negotiating. I'm not afraid of a just fight, but being a litigator, what litigation I've done, I just all day long, we're just arguing and fighting and not trying to find any shared truth. Usually we're just putting up the best defense we can. And that just can get really old to me. My psyche and just my desire to find, again, shared truth and what works. I mean, I love that about M&A. We come up with, okay, maybe we got to compromise here a little bit, client, but what if we would do this? Come up with a solution that both parties can accept. It's the kind of compromise where they're both, relatively happy, not both like a settlement litigation is a compromise where they're both unhappy. So that's great. And then it's also, it's not a bad practice. I mean, it's good from a billing perspective. Clients have money for M&A. They're seeing a lot of your hours because you're on calls. They're seeing your emails go back and forth versus contract drafting where you're just behind your desk and working on it for hours and hours, and maybe things get a little bit tricky. They don't know why. And so it's an easier space to bill. And I think clients have more budget set aside for it. It's easier to deal with money. So it's not like we make tremendously more on it. It's just, it's easier, I guess, and clients are ready to pay for the service more, and they're more careful with the contract. What are you doing, and why did it take so long, and things like that. So that's helpful. On the con side, okay, the hours, right? So the deal trajectory I talked about, that it gets really busy at the end. That can keep you up late nights. And in big law, I talked about doing deals where you've got public companies involved. You can be up all night. I mean, all night. And so the first week I was back in law after being out for about 8 years at one point, I was working on a major public deal for a large law firm. And I think I billed 110 hours, something like that week. And you're at that point, you're billing almost every hour you're in the office. Versus a typical day, you just have downtime and you're talking to people and things like that. Maybe you bill 80%, but that's a lot of time. What does that work out to? 15 hours a day? Yeah, that's got to be right. 15, 16 hours a day. So when you have time to sleep, well, you don't sleep much. And by the way, like some of that, it probably didn't work much on like the Saturday or Sunday. Some, okay, but not much. So in other words, the major working days, you're there 18 hours a day. Now that's not typical of most M&A lawyers, but even in my practice now, where we don't work with public companies, I mean, it's not to say we can't, we just haven't. We're a two-person law firm. We kind of work on the call it $2 to $50 million range is our sweet spot there. And after that, we start to, the deals go somewhere else, even though, again, they need not to, but they just do. So they're still at the end, you got a closing date set. People are looking to you to move this thing along. Things come up that weren't accounted for. And you've got to figure out a way to get that issue taken care of. Something more needs to be drafted. You've got to figure it out and still get to that closing date. So that drives a lot of things. And because there might be exclusivity under the letter of intent that will expire soon if you don't get this closed, so the buyers are worried about that. So it's go, 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 go. So that has you up late hours. It's not odd for me to be working at midnight on a deal, but not every night. So again, I don't mind that. I don't want that every night. It's certainly, but the deals you gotta work on the deals when they're there. Another con I would say is, I like this too about the practice, but some people don't love all that emotion. It can be a lot. Sometimes you can feel a little bit like a therapist. Not like if you're a family lawyer. I mean, I think all day you must feel like a therapist, but some amount of it is because it's a major thing, and sellers are sometimes having seller's remorse, and buyers are getting cold feet, and there's a lot of things going on there, and that's not maybe that unique. I mean, there's a lot from other practices of law. I mean, there's some that's not the case at all, I would think. But in litigation, you've got clients who are very unhappy, and you've got to counsel them on non-legal issues, like just in how to handle this and how to, again, contextualize the word I use many times in this video. So there is a lot of that. It's a very emotional experience. And then I would say due diligence and disclosure schedules are not my favorite part of the job. They're very routine. Now, fortunately or unfortunately, a lot of that work is going over to AI and automation. So, and at this stage of my career, less of it would fall to me anyway, but that stuff was never super exciting for me. I hated it as a junior associate at a big law firm. It was just mind-numbing. And I understand you got to pay your dues and do what you got to do. That's how it goes. But it's not the most fun part of the job. Now, every job has things that aren't amazing, right? But this is that would be the one in M&A almost for sure in my book. So let me throw one other positive out. And I did a video recently about AI and its impact on law and mergers and acquisitions specifically. AI is everywhere and changing the nature of the practice, changing the nature of every profession. It's going to be a very, very big game changer, particularly at those lower levels, that routine sort of work. I think M&A is more. I can't imagine, I guess I can't imagine, but I don't see even out 5-10 years, clients saying, look, I'll have my AI agent talk to your AI agent to figure this issue out. I mean, there's still negotiations and deal management and things like that feel like if those are gone one day, everything, it's like nothing is like it is today. In other words, those areas are pretty protected from a lot of the, from what AI is doing. And look, and it's not like this is AI fundamentally is helping us do our job, but it is going to take some work from some lawyers and create friction. And M&A law feels a little protected from that. So anyway, if you've got general questions, drop them down in the chat. If you like this, hit the like button, subscribe. If you've got specific questions, you can get me at clarity.fm/Brett Cenkus. And I appreciate you watching today.